So having looked at all the things we can appeal, we're now going to look at the actual process of the appeal. And this is quite a big one. And this covers all of them: refusal to assess, refusal to issue, contents, refusal to amend, and cease to maintain. It's much the same. There's one or two things we'll look at that are slightly different. It's much the same throughout, but actually, how do you do it? So one of the things you'll get if we're looking at, excuse me a second, if we're looking at a simple refusal to assess, this is the very first stage, you'll often get a letter saying, we're not going to assess your child. We're not going to look at them. We're not going to assess them. And they'll give the reasons why. And a common thing you'll hear is, please go and discuss the concerns with your child's teacher or SENCO. They hope that you might be able to sort it out with the school, and the school will put the right support in. Discuss your concerns with your SENDIAS service. That's also always worth looking at. They have to give you the details of how to go to mediation, and they have to tell you for your right to appeal. You need to keep a really careful watch out for the timescales on this. We had a family recently who followed this to the letter, didn't get very far with the school, contacted their SENDIAS service, who took 6 weeks to reply. And by then, they'd missed the timescale for mediation. And by the time I got hold of them, they were 2 days off the final time that they could put in a tribunal appeal. So we had to do it incredibly quickly. And we did get it in, and it was successful, which was good. And that child now has an EHCP. But you need to keep a very, very close eye on the timescales. They are really important. You mustn't miss them. They can miss all their timescales, the other end from the local authority, but you can't. So your letter will tell you why they've refused to assess. And one of the really good resources is IPSIA have a refusal to assess pack and a refusal to issue pack. These are going to be sent to you, if they haven't already, by Look, as ready to just open up. But you can also get them from the IPSIA website. They're very good. Actually, they're really good. It's like a kind of ABC guide how to do this. Mediation. First of all, what is mediation? Mediation is where an impartial professional, they have to be impartial, who's the mediator, helps both sides work out an agreement. It's confidential, and it's usually much quicker than going to tribunal. So that's what mediation is. It's voluntary. You don't have to go to mediation. It may or it may not lead to an agreement. You may come out of mediation and be happy to move forward with the decisions made. The local authority can change their minds at any time at mediation. So if they've said no, they can change their mind to yes. But the tribunal will not take into account, if you're not happy with the mediation results, they will not take into account whether or not you did or didn't go ahead with mediation. So you don't have to, and they're not going to wrap your knuckles and say, well, you should have gone to mediation. So you don't need to worry about that. And any outcomes or actions that are agreed at mediation will not be shared or considered by the tribunal. They're very different processes, and they want people to consider mediation because it can save time and money and stress. But at the same time, they don't want you to feel that that's going to impact your chances at tribunal, because it won't. They won't even look at it. So you don't need to worry about that. How to access mediation? They have to give you the information about mediation in their decision letter. So when the local authority write and say, we're not going to assess, they must tell you how to contact the mediation people. You can also contact the Independent Mediation Service with the phone number that you'll have in your packs. Once you've been through mediation, you get a mediation certificate regardless of the outcome, and you'll need that if you want to go to a tribunal. And this is a really important thing that sometimes people miss, and it can make things very difficult. If you don't want to go ahead with the mediation, which is your right, you still have to contact them to get the certificate. Even if the certificate just says that you didn't want to go ahead with it, you need to do one or the other. You need to either go to mediation or ask for a certificate to say that you haven't gone to mediation. If you really miss that and you haven't done that, you're going to need to explain that to the tribunal. And if you've got a good reason, it could be your child was severely ill at the time, you were in hospital, yourself, your child, another child, they'll be quite tolerant, but try wherever possible to follow the steps of mediation. You have to take part? No, you don't have to take part, but you do, as I say, need to have a mediation certificate to lodge an appeal. The only time you don't have to consider mediation is if you are only appealing section I, which is the placement where your child's going to go. If that's the only thing you're appealing is where your child's going to go, you absolutely don't have to get a mediation certificate. You can just go straight to the tribunal. So if that's the only thing you're appealing, you don't have to do mediation. So assuming you've either decided not to do mediation or you've done mediation and you're not happy with the outcome, your next step would be to go to the Special Educational Needs and Disability Tribunal Service. I would say that if you're looking at this stage at refusal to assess, it's probably worth trying mediation. It does you no harm. It does your case no harm. And a lot of them, I can't tell you how many mediation meetings I've sat through. And I just say very calmly, this child meets the legal criteria for being assessed. And you know, if it goes to tribunal, that's what they're going to say, and you're going to have to do it. And I was going to say 9 times out of 10, for me, 10 times out of 10, and nationally, 88% of the time, that will go that way anyway. And quite often, just saying to the local authority that you know the law and you know that your child meets the criteria for assessment will sometimes work. So I'd say if you're appealing for an assessment, it's really worth considering mediation. It's much quicker, much less stress. But if it does go to tribunal, these are the details for the tribunal service. There's a website, you can contact them by phone. They also have an email address at the bottom. They're pretty good at replying. Unless you're unlucky and you get one that's not so good. I've found both of the people who answer the phone are pretty good. They're not there to be, they're impartial. They're not there to be on your side, but they are there to give you all the information you need to help you appeal. And on the whole, they're fairly supportive with that. The SEND tribunal can order a local authority if you go through tribunal and your case is won, to carry out an EHCP needs assessment, to issue an EHCP, to amend an EHCP, to maintain an EHCP. And the local authority has absolutely got to comply with these orders if they're made. The SEND tribunal can also make, as I said before, non-binding recommendations about health and social care. So it's a free service, unless you choose to use, if you can afford and you choose to use paid legal support and you don't qualify for legal aid, this is a completely free service. So that's actually a good thing to know. As I say, they're very helpful, they're impartial. They have some really good resources on their website. They have a free booklet called How to Appeal. They have some fantastic YouTube video resources where you can actually see what it's like in a tribunal service. There are also, as I mentioned before, the IPSIA packs about refusal to assess and refusal to issue. But if you're going to tribunal, which will these days almost always be on a video, the one I did today was on a video link. The YouTube resources are really helpful because you can feel quite intimidated, and actually there's no need, because actually they're not done to be against you as a parent. So it's worth looking at those. Just very briefly, the decisions made by the tribunal are based on the law. They're not interested in how people really, who's right, who's wrong. They are just looking at the law. And if your child meets the criteria for what they deserve to have in terms of support in the law, that is what the tribunal will uphold. There are some major bits of law that they work from. There's the Children and Families Act. There's the SEND and Disability Regulations. Both of those are their absolute binding law. There's also the very good SEND Code of Practice, but that's guidance rather than law. And the tribunal doesn't have to follow it quite in the same way as it would the other two, but it will, on the whole, adhere to the SEND Code of Practice. In really complex cases, that you may look at previous SEND law cases and say, well, this happened then, so it can happen again. And I do that occasionally, but that's quite hard to do. This is a question I know that's been asked about evidence. The SEND tribunal will really want to look at the evidence that you and your local authority put before it, and they're going to make a decision based on what is right for your child or young person according to the law. But they can't make the decision if you haven't given them the evidence for what your child needs. So it's really important that you get this evidence to them. You can reuse many of the same reports at a refusal to issue as a refusal to assess. So if you've already been through a refusal to assess tribunal, chances are you won't be doing a refusal to issue. But if you're doing both, it's fine to use the same evidence more than once. So the evidence is going to be very different from everybody, but the things you're looking for are information from people working with your child, SENCO teachers, OTs, your GP, reports from information sent with the initial refusal to assess, previous EHCPs, annual reviews, second opinion, or if you can afford it, a private assessment and reports. There was a question earlier on that came in before the session about local authorities say, we're not going to accept that, it's a private report, it's not from the NHS. Actually, that they can't, they do have to look at your reports. They can't just say because it's private, they're not going to look at it. And there is actually somewhere in the SEND Code of Practice which states that that is the best practice. Chances are a tribunal would not look favourably on them ignoring a good report, regardless of whether it's come from a private medical person or the NHS. Reports from the school that you want your child to go to can be incredibly helpful. If they say they can meet your child's needs and you want them moved to a school, that's really helpful. And reports from the school your child is currently at, especially if they say they can't meet your child's needs. And it's a brave school to say we can't meet need, but it's actually one of the most helpful things that they can say. So that's also worth remembering. Hello? Sorry, I just heard something, but I'll just move on. You may be offered a paper hearing, and this is a big thing. It's like the tribunal hearing will either be done on paper, where you're not there and the local authority are not there, or it will be done with you there, like the one I did today. And there are the hearings are normally done now online. There's various pros and cons really of whether you go for paper or not. So the pros of a paper hearing is that it will on the whole be heard much more quickly. The cons are that you're not there to present your case personally in a paper hearing. At the same time, the local authority aren't there to present theirs either. You can't have a witness at the paper hearing. So if you're really relying on witnesses, then that's probably not the right thing, but then nor can the local authority. And also, sorry, I'm just moving my screen again. If both parties have to agree to a paper hearing, so if the local authorities say, yes, we want a paper hearing, and you say no, it's no, it will go to an oral hearing. And the same the other way around. If you say you want a paper hearing and they say no, it will always go with the person who says they want an oral hearing. So you don't need to worry about being pushed into that. What I would say is we sometimes do go for paper hearings for refusals to assess if we're absolutely sure that that child meets the criteria, because they'll be heard so much more quickly. But sometimes if the cases are more complex, we prefer to have an oral hearing. So what actually happens at the oral hearing is obviously important. You need to bring the bundle of paper. They have this thing called a bundle. It can be very intimidating because it all has to be in order. You're not responsible for creating this bundle of paperwork, which has all your evidence and everything that's needed. The responsibility actually lies with the local authority. It's really important if you have a bundle, whether it's electronic or paper, you keep it in the same order that it comes, because they will refer to certain pages. And it's good to keep it in the right order. They're not happy. The judges aren't happy if you're going, oh, I don't know what page I'm on, a bit like I'm doing today. They expect it to be in the right order. The hearings are led by a panel, and for most hearings, this is a judge and one or two specialist members with SEND experience. It sounds really daunting, but on the whole, they make it quite fair. They understand that you as a parent or a parent carer will not have, your local authority will probably have a legal representative, and they know that, and they will not let you be disadvantaged because you don't. And you need to have confidence in them that today I don't have any legal training. It was me and a parent, and it was a legal representative for the other side, and they're really good about not letting you be trampled on. They will have read your bundle of paperwork in advance. They will have identified all the key issues in advance. They may well have more or less come to a decision in advance, but they don't tell you that. They will ask you questions, and they very much take the lead. So you don't have to think, do I say, don't I say? They'll take the lead. It's really worth taking notes. You'll certainly get your turn to speak, and you can also ask to say more things. And be aware of the formalities. They're not hugely formal, but I always ask, and like I did this morning in a tribunal, how would you like to be addressed? And it's normally Judge or Judge Smith, and they quite often like to be called specialist member or panel member Jones, panel member whoever else the other one is. So if you're not sure, just ask. How would you like? Some people like to be called sir and madam. Just ask, and they like to be asked. It's a nice thing to say, because solicitors will know straight away what to call them. But it's always worth asking. We're going to just look really briefly at witnesses. A witness should have knowledge of your child in a professional context. And if your appeal involves a school placement in Section I, it's helpful, if not essential, to have a witness from your choice of school. So that's really good to know. There's no legal bar on the number of witnesses, but tribunal practice limits it to 3. You can have more than 3 witnesses if you really need, but you have to apply especially to the tribunal for this. If you have a witness who's been told they can't attend, so we're in a position where we wanted people from the local authority, like QTVIs, to be our witnesses, and the local authority didn't, and they were told to say no, we can't. A couple of them really wanted to be our witnesses, but they were told to say no. It doesn't make any difference, because if they say no, you just have to get them summoned. So I don't know why they say no, because you just have them summoned, and it just takes more time. You apply to the tribunal service, you say, I need to have these people summoned. You've probably seen this in films, films with legal things where someone serves a summons. Well, it's pretty well like that. You have the responsibility to make sure that summons gets to your witness. And I remember in my case that involved quite a bit of driving in such a large rural area. And one of my witnesses who wanted to support us agreed to meet me at the services, so I didn't have to drive so far. We had a cup of tea, and I summoned him very formally with this piece of paper, which was but yeah, if they say no, you just have them summoned. Witnesses can claim expenses and loss of earnings, and they must have previously provided a written report or witness statement. So again, it sounds all very kind of scary, witnesses, but it's fine. It's not as bad as it sounds. The next thing we're going to look at, and this is something I mentioned before, is timescales. They are so important. This is the one thing they will be quite strict about. The request for mediation must be made within 2 months of your decision notice. If you choose to go through with mediation, you must notify the local authority that you're doing it and arrange a meeting, which should be completed usually within 30 days. The deadline for appealing to a tribunal is 2 months from the date of decision, or 1 month from the date of the mediation certificate. So if it takes 6 weeks to arrange mediation, you've then got another 4 weeks. But if the mediation happens within the first 4 weeks, you have to get the tribunal requested within 2 months in total. And it's really important to do that. Time is absolutely crucial in this. Once an appeal is lodged, the local authority must respond to the tribunal within 5 weeks. And this is the one area they tend to do on time. You should hear back from the tribunal service within 2 weeks. The date for the hearing should be within 10 to 12 weeks, but at the moment for oral hearings, we're looking really in most areas between 6 and 12 months. That's why if it's something where we're fairly certain that we're going to win, we tend to go for a paper hearing. I'm looking now at 8, 9, 10 months in our area waits for tribunals, and that's another year of a child's life. It's really dreadful. The reason it's so long is because the tribunals are totally overwhelmed, because so many people are appealing, and so many people are appealing because so many EHCPs are being refused. It's an incredible waste of money. These things cost the local authority a lot of money. They have to employ solicitors. I always feel that the money would be better spent on the children personally, but that's my view. You will get once the tribunal has been completed, like the one we had today, they will always say that you will hear from the tribunal in writing, usually within 2 weeks. They will tell you if they need longer, but it's nearly always 2 weeks. So we're just going to look at a few odd what I call odds and ends now. So children in phase transfer. So you may be looking at this 6 to 12 month thing and thinking, but my child's due to go from primary to secondary school in 3 months' time. If your child is in this stage, you can ask the tribunal for the date to be moved forwards, and on the whole, they will comply with that. If you have a child coming up to a transfer, make sure their review meetings are held as early in the year as possible. So if you normally have your review meeting in December, ask for it in September. If it's in March, ask for it in January. It's really important that you give yourself time for the local authority to make decisions, especially if they're going to cease an EHCP. So you've got time to chase them up. If they're not contacting you about their decision prior to the legal stage, you need to chase them all the time. They are terribly behind. You know, when I wrote one and say you're now 59 weeks behind, it's because they're desperately underfunded. They don't have the staff. That may not seem like a good excuse, but it's why it's happening. Apply for mediation as soon as if you apply for mediation or the mediation certificate as soon after receiving your decision as possible. If you wait for a month and 3 weeks rather than 2 months, you're then stalling yourself, not them, and you need to do things quickly because you may end up waiting a long time and consider a paper hearing if you have a child in phase transfer. This is another important sort of side issue. If your child is not attending school at all, if they're out of education for whatever reason, the local authority may be considered to be falling short of their duties under the Education Act. If your child is unable to attend school due to exclusion, mental health difficulties, or any other reasons, they do have a duty to provide a suitable alternative education. That does not necessarily mean home education, because if you go for home education where you're responsible for your child, you will not get the SEND support. If your child can't attend school, I've worked with a family recently where the local authority are now providing home tutors. They have to provide your child with an education. And that can also be quite a battle. But it is really important to look for that. I said that there's a few very, very small differences, and this is just one of the important ones. That of all of those appeals for assessments, issuing, amending, the burden of proof is on you to prove that this is what your child needs. However, if they are trying to cease an EHCP, the burden of proof becomes the local authorities. They have to prove that the child no longer needs the EHCP rather than you having to prove that they do. Whereas, as I said, all the other cases, you've got to prove that the child needs the EHCP or needs the amendment. But in this case, they have the burden of proof to prove that that they don't need it anymore. You can still submit evidence, and we strongly suggest you do, because that's really helpful. And if you're going through a cease to maintain appeal, the current provision in the EHCP must be maintained during any appeal, including the 2 months that you have to register for a tribunal or request mediation, even if you don't want to do mediation, and until the outcome of any such appeal. Now, if it takes 2 months to go through mediation and starting the appeal, and then you wait 8 or 9 months for the tribunal, they have to provide the current provision in your trust plan all throughout that time. It's really important. It's only if the appeal is unsuccessful that the LA would be able to cease to maintain the EHCP provision immediately. That's the only time they can. So don't let them say we're not going to provide this until the tribunal say we have to. They have to. They absolutely have to until it's been decided. I did say before there are other means of raising concerns about other areas that go wrong. If you're not happy with other aspects of your local authority, such as timescales and the things that you can't appeal, it's really worth having a look at the Ombudsman Service for local authorities, and for various other things. So if you're not happy with the health provision in the plan, you can complain via the NHS complaints procedure. And like I say, you'll have all of these packs to work from. If you're not happy with the social care, you can complain to the local authority using the local government ombudsman, which is also the same people to use if you're not happy with timescales. And again, this isn't in here because I only read this in the news on Saturday. The local government ombudsman who take complaints for local authorities say that 26% of their complaints are about SEND. And that's huge if you think of everything that a local authority has to do. And 92% of complaints to the local government ombudsman about SEND are upheld in the favour of the parent. And that what they're saying is this is absolutely terrible, because if 92% of these parents are right, then something's obviously going wrong, as if we don't already know that. But if you do put in a local government ombudsman appeal, one area where it differs from a SEND tribunal is a SEND tribunal cannot order any kind of compensation at all. But a local government ombudsman hearing can. And I've seen parents get not a fortune, but a good bit of compensation. And you can do more than one. And we've got some parents on their third at the moment. If you're not happy with the way that your school or local authority are providing the contents of your child's plan, you would then have to go to a disability discrimination tribunal, which is hard work, but that's what I was doing today. It was that they're quite winnable. And finally, don't forget your MP. It doesn't matter whether your MP is the person you voted for or not. Whatever party your MP is from, compared to whatever party you favour, they have a duty to support you. And we drag in our MPs left, right, and centre. They're like my best friends now. They can have a lot of sway with local government, with local authorities, and with disability discrimination cases. In fact, we've just managed to avoid a disability discrimination case with the help of an MP who said, look, you know you're going to lose this if this goes ahead, and the authority backed down. So that was good. Very quickly, border issues. England is divided into so many local authorities, and it's not uncommon for a child to live in one but attend a school in another. It could be literally 10 yards up the road and it's another local authority. The local authority you live in will always be responsible for your child's EHCP and SEND provision and all associated costs. They may have cross-border agreements with neighbouring local authorities regarding how this provision is delivered, but they are responsible for it. So, for instance, if I look at, say, Devon and Plymouth, if a child lives in Devon but goes to school in Plymouth, Devon have to pay for or provide or pay Plymouth to provide that child's support. And don't let them tell you otherwise, because they may try. And we've had children wait a year while local authorities wrangle about who's paying for it. So we just say, actually, no, you're paying for it, full stop. So that's also good if you're living in a border area. Legal aid is something that's worth thinking about as well. You have to be on a pretty low income to qualify for legal aid. It can cover preparation of the case, cost of new reports, but it won't cover representation at the hearing. They won't be at the hearing. The thresholds for legal aid are given. You can look in your pack. It's fairly low for a family of 4. They will take into account your disposable income. So they'll look at what you're paying in tax, insurance, mortgage, rent, childcare. However, if you have a child who's over 18, you may find that even if you're earning more than that, that they may qualify for legal aid in their own right. I've seen some great cases be won with really good legal aid support, and I've seen some fall apart with really poor legal aid support. So it's really important to make sure that if you are using legal aid, that they know what they're doing and that they are experienced in SEND and that they're doing what you want them to do. Because it's a great service, but you just need to check that they do know what they're doing. So just briefly about other support, who we are, all our details are there. Look, who do so much more than these sessions. They do their mentoring sessions and all sorts of other things. We, unfortunately, are only Devon, Cornwall, Somerset and Dorset, and Devon includes Plymouth and Torbay. And I sadly can't take on cases outside that area because I'm already stretched to my absolute limit. Blatchington, of course, provide an absolutely cracking service in Sussex as well. That is for families in Sussex. However, if you don't live in one of those areas, you don't need to worry. There are lots of other sources of support. There are VI specific support organisations. Guide dogs they have an entire service which will give you lots and lots of information, advice and advocacy support around SEND education. As far as I know, they don't go up to tribunal level, but they are really good at looking at things like what should be in your child's EHCP and all the information you need to get you to this appeal level. They might not be with you at the appeal, but they will support you up to that point. Victor, as well as having amazing other activities, have got lots of useful information on their website. RNIB have lots of information on their website. Nystagmus Network have some educational advocacy support. PAN disability support, particularly for anybody, particularly if your child has other disabilities. There's a list there. If you want to find your local SENDIA service, I'm aware some of them are being not completely cut because they have to exist, but they're being, shrunk. IPSIA are great. SOS SEN is good. SENT is really good because they now cover lots of disabilities. And Special Needs Jungle, who I do rave about, are really worth having a look at, if only just to cheer yourself up, really. If you live in Scotland, Wales and Northern Ireland, have a look at that. There's lots. If you live in Northern Ireland, Angel Eyes are absolutely incredible for children with vision impairment. I'm sure if you live there, you already know about them. They are really good. So there's lots of support there. Wales is SNAP Cymru, and then there's a few in Scotland as well. So it's worth looking at them. So finally, I just want to say before we ask any questions, I know Luca very kindly extended this session by 50 minutes because there was such a lot to cover. Don't forget, please don't forget, the law hasn't changed. The law is still on your side. If your child has or may have a special educational need that may need provision met through an EHCP, they have got to be assessed. And that law hasn't changed. I'm not asking you to go away and read the Children and Families Act, but it is there. And whatever plan is in place, including all the new ones, the law hasn't changed and it's still there. It's still there for you.